let's start with yesterday's 303 Creative versus Elenis. Mark, tell us about this case.
Yeah, so this is the case about a Colorado website designer who sued in federal court because she does not want to make websites for same-sex couples who are getting married. No wedding websites for same-sex couples. And she claims that she has a First Amendment free speech right to refuse to serve any same-sex couples who come to her and ask for a wedding website. Now, a twist here.
Let me just one thing.
Okay.
She doesn't have to do any of this. What she wants to do is have a business licensed by the state, use the state's apparatus to exchange funds and everything that's involved in that. She wants to use our resources as a society and engage in commercial activity, which is licensed by the state, and decide not to serve specific people, right?
Even though that situation has never actually come up for her, by the way, we should point that out, that she hasn't been asked to do a gay person's wedding website.
Oh, she will be soon. But I mean, that's the point ultimately, right? I mean, is that nobody's forcing her to do anything. It's just that there is, in the same way that, I have to obey the laws of the road if I'm going to drive. She's got to obey the laws of this country if she's going to use the country's apparatus to make money.
Right. So I think that's true on two levels. First, as Emma noted, no one has ever asked her to make a wedding website, let alone a same-sex couple. So this whole thing is theoretical. No one is forcing her to do anything, period, because she mostly makes websites for local Republican politicians and dog breeders. But to your point, Sam, yes, this is an important distinction that gets lost in the case. Colorado conceded time and again that if this individual were a freelancer or a contractor, or she lent out her services on a client-by-client basis, someone like Annie Leibovitz would come to mind as an example of that kind of artist, then they could discriminate against anybody. It's totally fine for them to say, I won't serve gay people, I won't serve Black people, whatever. But once you open a business and you are presenting yourself as a for-profit company to the public, at that point, Colorado law kicks in, and you can't turn away people on the basis of their identity.
And this is not any different from having a restaurant and saying, not going to serve Italians, right? I mean, is it?
So on some level, I think you're right. And I think that is the correct level. At the end of the day, there's no difference between a website designer turning away gay people and a restaurant turning away Italians or whatever, because they're both acts of discrimination on the basis of identity. This individual...
Protected identity.
Yes. We love the Italians. They are definitely a protected ethnicity. This individual, Lori Smith, who makes the websites, she says that she's not discriminating on the basis of identity, that she's only discriminating on the basis of message because she does not want to express her support for same-sex marriage, which takes this out of the realm of a restaurant discrimination case where you can imagine a server saying, well, I don't want to express my support for Italians by serving them spaghetti and meatballs. She thinks that it's totally different when you're talking about a website design. But, and this is another kind of layer that I hope we can keep at top of mind, she has never actually been told by the state of Colorado that she has to create wedding websites for same-sex couples. What Colorado told her is that if she creates templates for websites, if she creates a wedding website template that she sells to different clients and customers, that she has to make that template available to gay people. So after she has actually created the artistic product, only then does Colorado say, okay, now you have to sell that product to all comers equally. And she is saying that even that violates her freedom of speech because simply selling this template will involve compelled expression in support of same-sex marriage. And I think that's a really dumb argument. And I don't think it's any stronger than a server saying they won't serve Italian spaghetti and meatballs.
Well, that's the point. It's I'm serving food. I mean, of course it's, if I own a restaurant, it's an act of love and or it's not. I'm giving it to the people as they come in. If I'm going to offer it to the public, this is a restaurant where we serve you food. I don't get to choose who is a legitimate eater of that food when they come in based upon, race or sexual orientation or religious belief that the Supreme Court has already ruled on. It seems to me like even the idea of saying at this juncture marriage equality or like same-sex marriage, that's done. There's marriage. Like we didn't have to say, we don't say, opposite sex marriage. Like it's marriage at this point. That is we have already spoken as a society. It is no longer controversial. Seems to me that like if she had argued, 15 years ago, I'm not doing a gay wedding website because there's no such thing as gay wedding. Like there's no gay marriage in this country, but now there is. And so it's just marriage. It's just a wedding. If you're doing a wedding, you're doing a wedding.
So Lori Smith and her lawyers refer to same-sex marriages as false marriages. They say that they do not acknowledge or accept the existence of marriages between two people of the same sex. And so even working with same-sex couples as clients, even to the point of simply selling them a template for a wedding website, that would require her to speak in support of false marriages that violate her religious beliefs.
If I belonged to a religion that did not believe in the Supreme Court, could I like, I'm sorry, guys, like I don't fake court.
Well, I think you should certainly try because that would make an interesting test case. But I think if we take a step back, like your question points to the broader issue here, which is that there are certain rights and certain groups that the Supreme Court clearly favors over others, right? Like if this were a case of a Muslim business turning away a Christian customer, we would not be here. It wouldn't have reached the Supreme Court in the first place. This is not really about a broad, neutral principle of freedom of speech. And I think that if you just scratch at the surface of this case, that becomes so obvious because of the way it's argued. It is argued along the lines of Christian orthodoxy to give Christians a kind of get out of civil rights law free card and exempt themselves from non-discrimination rules by simply saying that engaging in some kind of business transaction constitutes a violation of their free expression because they're expressing support for some identity or whatever. And that, again, is a really dangerous argument because, as you pointed out, it just goes so far beyond a wedding website. It goes far beyond anything we recognize as speech, and it could encompass the baker, the florist, the restaurant, the venue owner. Pretty much anyone who sells anything could try to use this claim to discriminate against gay people or other people, interracial couples, interfaith couples, whatever. There's no limiting principle.
Well, Alito
let's do this with KBJ for a second, because she made this point because, it was a religious tenet not that long ago, probably in some circles, still a religious tenet, that black people and white people should not commingle, at least in terms of marriage. And then slavery was also justified on religious grounds. Here is KBJ trying to sort of like bring out sort of this dynamic. She is speaking to Kristen Wagoner. She's the attorney for 303 Creative, not the eternity. All right, let's play this.
So I'm sorry. Can I ask you a hypothetical that just sort of helps me to flesh that out? Because I also heard you suggest earlier that there's something different about race. Maybe the person wouldn't sell to someone of a different race. So suppose you say that photography is expressive. Can you give me your thoughts on a photography business in a shopping mall during this holiday season that offers a product called Scenes with Santa? And this business wants to express its own view of nostalgia about Christmases past by reproducing classic 1940s and 1950s Santa scenes. They do it in sepia tone, and they are customizing each one. This is not off a rack. They're really bringing the people in and having them interact with Santa, children, because they're trying to capture the feelings of a certain era. But precisely because they're trying to capture the feelings of a certain era, their policy is that only white children can be photographed with Santa in this way, because that's how they view the scenes with Santa that they're trying to depict. Now, the business will gladly refer families of color to the Santa at the other end of the mall who'll take anybody. And they will photograph families of color in other scenes. So they're not discriminating against the families. What they're saying is scenes with Santa is preserved for white families, and they want to have a sign next to the Santa that says only white children. Why isn't your argument that they should be able to do that? And maybe it is.
Because in the photograph itself, the objection is not contained in that photograph. But in addition, I think it's important to remind the court that—
No, don't leave. Sorry. What do you mean? I mean, the objection, just like your client's objection, is to expressions that violate their own views of what is being depicted. And so their view of what is being depicted is that a scene with Santa and a child on the lap and all of that in sepia tone, trying to harken back to the good old days, should only have white children in it. That's their firm belief. They are not willing to take photographs of Black, Hispanic, Asian children on Santa's lap. Why is that any different than a situation like this?
Because the specific objection that you're including is not necessarily in that photograph, but even if it were, this court has protected vile, awful, reprehensible, violent speech in the past, and it is never compulsory.
No, I'm just asking you, why is the objection of the web designer, as Justice both Kagan and Sotomayor has pointed out, when we look at your examples, they just say things like, please come to the wedding on this day.
Precisely. It's an invitation to a wedding.
Okay, so if my hypothetical is an invitation to join me in the 1950s through looking at this photo, you say one is different?
I say that same clarity of the message isn't in that photo, but there are difficult lines to draw, and that may be an edge case, but this is not. We have a creative—
that may be an edge case.
An edge case.
Yeah. I mean,
so, in other words, close call. Like maybe it could go either way.
Right.
Like maybe we could deny Black children sitting on Santa's lap if we're trying to make it look like the 40s and the 50s. It's just, that's my vision.
And think about how this cashes out in the real world, right? If that's an edge case, then the state governments that are charged with enforcing these non-discrimination laws, they are not going to bring actions in those cases because they're afraid they're going to get tangled up in a 10-year-long litigation hellscape. And so the further that the Alliance Defending Freedom and Kirsten Wagner push the court in this direction, the harder it's going to become for any state anywhere to enforce non-discrimination laws, because there's going to be this massive, weird gray area where nobody actually knows if it's legal to discriminate because only the Supreme Court can say for certainty. And so this is an invitation to really, I think, relax enforcement of non-discrimination laws by making it incredibly ambiguous where they cannot actually apply.
If you perceive it as a way of relaxing, I mean, that's the thing, is that the people have to understand these cases do not live in their own little sort of like siloed universes. These cases become building blocks and touchstones and leverage points and pivot points for a whole larger set of cases that are somewhat related to it. That case, and she's talking, as far as that lawyer is concerned, she's saying the case that the hypothetical that KBJ is introducing, the idea that like a Santa Claus in the mall, trying to recreate the 40s when, very unlikely that a Black kid would be sitting on Santa's lap in the mall in the 40s. We can exclude Black people, is an edge case now. If the Supreme Court was to rule in favor of the plaintiffs in this situation, it no longer becomes an edge case. There becomes a new edge case that is further out there. Like maybe we just finally get to the restaurant where it's like, when I serve food, it's an expression of love. I'm really creative and I don't want to, do it for two guys who are holding hands when they come in, or Black people, or whatever it is.
Yeah, and Alliance Defending Freedom has specific language that they tell their clients to put up in their business so that they can make this argument later. I went back and looked at this individual's website, Lori Smith, through the Wayback Machine. And for some years, she was just a normal website designer, right? ADF, the Alliance Defending Freedom that's representing her, they come along and take her as a client and have her totally rewrite her website to have this big statement about how every single website she designs, every click, every touch of the keyboard is an expression of her personal views that she's trying to communicate to the audience. You can imagine a freaking Olive Garden putting that up on the door, say every breadstick that we serve is an expression of love that communicates our views to our customer. There is no limiting principle here, and I think that's what KBJ so deftly pointed out.
I mean, don't give that work away for free,
Olive
Mark.
Garden, I
please.
feel like probably just stole that.
You need a consulting fee for that.
But so where does her religiosity come into this? Like, I mean, like, is it that, does she need to justify why this is her sort of like thing that she doesn't believe, that she doesn't believe that, despite the fact that it is the law in this country that gay people can get married, she doesn't believe it's real. Does she need to justify that by saying she's religious, or can she just sort of say like,
so
I don't believe it?
In this case, she could really just say, I don't believe it, because this is a free speech case. It was originally both a free speech and a free exercise of religion case, but the Supreme Court only took it up as a free speech case. And so that means the onus, the burdens on her are very relaxed. All she has to do is say, look, there's a message that I want to communicate and a message I don't want to communicate. And I am being forced to communicate the message that I disagree with, and say that by simply providing a template to gay people, she is communicating her message. But ADF wants to make this as easy as possible for them once they're in litigation. Hence the finessed lawyer language that appear on all of their clients' websites and in their stores, explaining how their work, their act of baking a cake or putting together flowers is really an expression of their personal views.
You know, we interviewed, I think it was Susan Mettler on this program years and years ago about the use of First Amendment, not just in these contexts, but also to have businesses get rid of all sorts of types of regulation on them because it's inhibiting their ability to express themselves if they're privately owned. Like, we just don't want to express employees need to wash their hands in the bathroom type of situation, and on and on and on. It makes this incredibly dangerous, because if it's not, if it's not even limited by having a, you know, pre-existing demonstrable religious issue with something, it just becomes, I get to choose whatever I want the rules to society to be, and that's it. Let's play this Sam Alito and this is a fun clip because am I listening to this right? Does he just sort of get like completely owned in some way and then lashes out a little bit, legally speaking? Because it sort of feels like it, that they're just not used to, I don't know, in his right-wing circles, they're just not used to anybody having the answer. And he thinks it's a real gotcha. And yes. All right, that's what I thought. Here is Sam Alito going back and forth. The other voice you'll hear is Justice Elena Kagan. The other man's voice you'll hear is Eric Olson. He is the Colorado Solicitor General.
Then I really will stop. Justice Jackson's example of the Santa in the mall who doesn't want his picture taken with black children. So if there's a black Santa at the other end of the mall and he doesn't want to have his picture taken with a child who's dressed up in a Ku Klux Klan outfit, that black Santa has to do that?
No, because Ku Klux Klan outfits are not protected characteristics under public accommodation laws.
And presumably that would be the same Ku Klux Klan outfit, regardless whether the child was black or white or any other characteristic.
Yeah, you do see a lot of black children in Ku Klux Klan outfits, right? All the time. Suppose that I mean,
that's him. That's when he says that about that little comment about you don't see black people in KKK outfits. That's just him trying to run away from his completely sort of like flabby thought experiment there, where he forgot that the whole point about this is that you have people who have constitutional protections because there has been a history of discrimination against these people, and the Constitution says you can't discriminate based upon these grounds. Like, he forgot all of that in his really flabby hypothetical, didn't he?
Yeah, I mean, he forgot the whole premise of the case, which, as you said, is about protected traits, right? Not protected forms of customer expression. Like, it doesn't matter if
like
the
no
kid...
shirt, no shoes, no service
Exactly.
would fall be unconstitutional in this hypothetical.
Exactly. It's just an irrelevant hypothetical, but I want to make the point that one of the reasons there were so many bizarre hypotheticals, because there was the thing about Ashley Madison, there were all these other bizarro questions. Those emerge when there are no actual facts for the court to discuss and to test its legal theories against. So in a previous case, Masterpiece Cake Shop, that involved a baker who discriminated, there was a whole record, right? This guy was sanctioned by the state for discriminating. We saw how the Civil Rights Commission responded. We saw the state's own interpretation of its law. This went through the state court. There was lots for the justices to work with and suss out exactly how this had gone down. Here, this is a fake case, right? I mean, it goes beyond a test case. This woman has never been asked to make a wedding website, and now she's suing for the right not to make them. And so the justices are forced to go down this rabbit hole of increasingly bizarro hypotheticals because they don't have anything real to ask about like they would in a normal case. So they just have to make this stuff up.
Okay, so that begs the question, why are we wasting our time with this? Like, why would the Supreme Court take a case where there are no damages, no facts, like nothing exists? This is like a law school class, right? I mean, like there's not like no, in law school, you usually will look back on existing cases. Like this is just made up whole cloth. People sitting around a bar. What if? Like, why is the Supreme Court taking this case?
So my intuition is that it has a lot to do with the reason ADF brought this case in the first place, which is that when this case started in 2016, ADF had a bunch of clients bringing similar claims: the florist, the baker, the photographer, the venue owner, whatever, right? And in each of those cases, the business had actually discriminated against a gay person. And there was an other side of the story. There was a victim who could tell his or her side of the story. And it was like a real compelling narrative between two sides, both of whom had deeply felt beliefs and felt like they were, facing discrimination. Here, of course, this individual never actually discriminated against anyone. And so there's not a sad couple who can be given media interviews to explain how hurt they were when they were turned away. There's not a real victim in this case because it's fake. And that has allowed Lori Smith, the discriminator here, to really become the victim. She has fashioned herself, and her lawyers have fashioned her as the victim of the state's discrimination against her. And because there's no other side, there's no other parties who actually were injured by her conduct, I think the media has really run with that narrative. Go look at how the New York Times, the Wall Street Journal, Washington Post, CNN, AP, look at how all of them covered this case. Big, gauzy photos of Lori Smith in her office, surrounded by Christian aphorism, super sympathetic interviews, really just biting this line that ADF has given them. And I think that is proof that this strategy has succeeded both in the lower courts and the media, and probably now at SCOTUS.
Wow. And so do you think they're actually going to rule in favor of her? And so now she's not going to have to do what she was never doing in the first place.
Yeah, it'll be really hard for her, right? I think they'll rule in favor of her almost certainly. I mean, the one question is whether there's two conservative justices who can say, maybe bringing fake cases is wrong. Maybe we shouldn't be condoning this. But I think that there's a sense among some of the conservatives like Gorsuch that they already waited so long, right? This was supposed to happen in Masterpiece Cake Shop, but Kennedy kind of backed out and then he retired, and they've already waited like 5 years. So they're not going to let this moment pass them by because they don't know how long they're going to have their supermajority.
And Alito was right. Like, he was trying to make some sort of distinction at another point in oral arguments I was reading between race and sexuality, right? So, like, are they going to try to find some sort of parsing of anti-discrimination laws where potentially they can, I don't know, have it both ways?
I think that's a possibility. I think that Alito's questions are not worth taking too seriously because in situations like this, he's really just trying to own the lawyers who he hates and make fun of the justices who he hates. But yeah, it so much depends on precisely how the decision is written and also whether the court decides to adopt a fake set of facts that promotes its desired theory, like it did last term in the Coach Kennedy case, right? The football coach who was praying at the 50-yard line, the Supreme Court just made stuff up about him to ensure that they could lay down the legal theory that they wanted. I think it's quite possible that could happen here, and Alito is teeing that up.
Let's move to tomorrow's case. With that said, again, all of these things, they're going to be with us. We're going to be citing this fake case in a year or two in the next sort of thing as we erode our civil rights laws in this country.